You fall from a scaffold or a ladder and you're injured. You need a lawyer. My name is Jonny Kool. I practice law in New York State. I'd like to just discuss with you some of the important factors of such an accident. First, you have to prove that you were doing a covered activity, meaning that you were doing demolition, doing construction, doing certain types of work that are specifically itemized in this law. You also have to prove that you're a covered worker, meaning that you are covered because of your standing as to the activity that you were doing at the time. You also have to show that there was a contractor, an owner that was involved in the project, and that helps because oftentimes in a construction accident you can't sue your employer. You can only sue a different party to maintain a third-party action, as it's called. Oftentimes it can be the owner of a project, a contractor, or an agent of those two. These are things that a lawyer looks at when you come and talk about your story, your accident, and your injury. Another thing is that under this scaffold law, you have to show that you suffered the effects of gravity, meaning that you had a gravity-related injury because of what happened to you. It doesn't matter how high a fall can be. It can be 17 inches, it can be 20 feet, it can be 100 feet. But it's capturing what happened in the accident. These are very, very important in discussing a case with your lawyer because that way you can strategize and plan. You also have to show that you were caused to suffer an injury as a result of this gravity-related fall. Now, one of the things that you must show, but it's not that hard sometimes, is that you were not the only cause or the sole proximate cause of your accident. Meaning, it wasn't all about you, that you didn't have proper protection, and because of the uniqueness of this statute, even if you're 99% at fault and 1% not, you'll win 100% liability. Be aware of that. There usually is a summary judgment motion in a case like this, meaning that a lawyer will bring a claim to a judge and ask the judge to decide the legal aspects of how the accident happened on liability. You need to have a lawyer that is prepared to be able to write papers to either win such a motion or to defend such a motion, because a case can be dismissed at that point. With respect to damages, a lot of you are union workers. Union workers have collective bargaining agreements. That enables an economist to project for years upon years based on historical data what you're going to lose if you can't work for the next 10, 15, 20 years. Very important to be able to have an economist that can itemize those types of damages because in the end it maximizes your damages as well as show the other side that this is a very, very significant case. In the perception of a jury, economic loss is extremely important. A lot of jurors don't mind awarding significant amounts of money for what an out-of-pocket loss is as opposed to somewhat more subjective facts like pain and suffering. So it's very, very important to understand what your damages claim is, what the economic side of it is, what the pain and suffering side is, and put it all together. My name is Jonny Kool. Call me.